All right, so let me get this back in presentation mode. Okay, everyone should be looking at a title slide on their screen that says the Secure Act. I'm up here in the top right corner of your screen. Hey, Joanne, thanks for joining us. We're just getting started, so you haven't missed anything. When I sent out the invitation to this, I told you the content would be about 25 to 30 minutes. In the session I did earlier today, I wound up going more like 40, 45 minutes. I will try to be very cognizant and aware of the time, but I do want to make sure we answer any questions that you guys may have along the way. So with that, we will jump right in. So what is the Secure Act? So I've touched on this in my email newsletter and some writing I've done on my website. The Secure Act was passed very recently. Secure is another one of those government acronyms, and it stands for setting every community up for retirement enhancement. I think a better name for the bill might have been accelerating tax revenue, but I'll touch on that a little bit more in a minute. It was passed in the House in July of last year, approved in the Senate in mid-December, and the President signed it into law on December 20th. It became effective this January 1st. So this is pretty fresh legislation, and it has a lot of moving parts, and a lot of changes are involved in this law. I'm not going to touch on all these because I really want to focus on the retirement specific aspects that I think will affect the most people. But within the Secure Act, there are some annuity related changes, which for any of you that know me, I'm generally not a fan of annuities. But there is some changes that allowed for broader use and adoption of annuities and 401ks. Again, I'm not a big fan of that, but it is what it is. There's new contribution eligibility for IRAs. So formerly, before January 1st, you could not contribute to an IRA beyond age 70 and a half. Now, if you have earned income, and that's important, you have to have earned income, you can now continue to contribute to a traditional IRA beyond age 70 and a half, if that is something that might be helpful in your situation. There is an expansion of 529 plans. You can now use up to $10,000 of 529 plan dollars to pay off eligible school debt, typically college loans. And that can actually be used per person. So you can actually use one 529 to pay off multiple $10,000 chunks of school loan debt per beneficiary. You just have to change the beneficiary of the 529 account to pay it off for a different beneficiary. There are some additional provisions to allow for penalty-free access to retirement account funds. Specifically, you can access up to $5,000 per childbirth or adoption event. So that's new and is just really trying to make your retirement accounts and retirement funds have a little bit more utility for things other than just retirement. And then there's a lot of other things too that get into small businesses and retirement plans and things of that nature. And again, as I mentioned earlier, if I keep glancing to my left, I'm just checking out the chat and Q&A and some other things there. So if anyone has any questions as we go, just type those in. The biggest changes, there's two really big changes that have come out of the Secure Act, and they affect both required minimum distributions and what are generally referred to as stretch IRAs. And I'm going to touch on both of those a little bit more here as we go. Required minimum distributions, or RMDs, if you see me using the acronym RMD, I'm talking about required minimum distributions. They got pushed back a little bit. So before this law was passed, before January 1st of this year, required minimum distributions began at 70 and a half. And I'm not sure why it wasn't 70 or 71. It's just one of those obscure government IRS things that they wanted it to start at 70 and a half. But now, under the Secure Act, required minimum distributions now begin at 72. And there are some stipulations around how that works and who's eligible. I'll touch on that in a moment. But it's important to know that RMDs, required minimum distributions, are important, and they have very steep penalties if you miss them. So just be aware of your obligations to pay required minimum distributions. I'll touch on the next slide about when they begin and how they may impact you. If you miss an RMD, meaning if you have to pay one in calendar year 2020 and you don't take it by December 31st of this year, there's 50% penalties, and it just creates a mess. So that's something you want to avoid if you can. So a couple of dates on this slide that are important. If you were born on July 1st, 1949 or later, so July 1st, 1949 or later, you do not have to take an RMD until you turn 72. If you were born before that, so if you were born on June 30th, 1949 or earlier, you're subject to the old required minimum distribution rules, and you will be required to begin taking distributions from your retirement accounts. And this is important, in the parentheses, whether you need the money or not, you're going to have to start taking that money out beginning at 70 and a half. So let me repeat that because that's important. If you're born on July 1st, 49 or later, you don't have to take an RMD until 72. If you were born before that, you fall under the old rules and have to start taking RMDs at 70 and a half. There are a couple of weird rules around how the actual RMDs work. So if you are eligible to start RMDs, whether you're required to start at 70 and a half or 72, you have to take your first RMD by April 1st of the year after reaching your RMD required beginning date. So in this example, let's say you are required to start taking them at age 72. You have to take your first RMD by April 1st of the year after your 72nd birthday. Another kind of weird twist, though, is that in addition to having to take your first RMD by April 1st of the year following your 72nd birthday, you have to take a second RMD in that same year for your 73rd birthday. So the way to think about this is if you want to defer it as much as you can, you have to take your first RMD by April 1st of the year after you reach 72, and then you have to take another RMD by the end of that same year for that calendar year. Your other option is you can take the RMD in the year which you reach your 72nd birthday, and then you could take your 73rd, your 73-year-old RMD in the following year, and then just kind of go on a calendar year from then on. RMDs, required minimum distributions, just a kind of a quick explanation. They are based on your prior year end account balance. So let's say you have to take an RMD this year in 2020, regardless of your age. What they do, what the IRS looks at is they look at your account balance in one or all, if you have multiple retirement accounts, IRAs, 401ks, et cetera. They want you to look at all those accounts, and they want you to look at the balance on December 31st, 2019. If, let's say you're 75, just to kind of keep the numbers simple, let's say you're 75 this year, you have to take an RMD, and let's say your life expectancy, according to the IRS mortality tables, is 87. That means that according to those tables, you've got 12 years of life expectancy left. So you take your account balance as of December 31st, the prior year, you would divide it by 12, and the resulting number is the dollar amount of your RMD. Then you would do that again the next year and the next year and the next year, and that's how RMDs work. But remember, if you still have a 401k at a prior employer, or if you have multiple IRAs, you need to calculate your RMD for all of those accounts collectively. So whether you do them individually or whether you collect a single RMD on behalf of all of those and take it out of a single account, you just want to make sure you get that right. You want to make sure you get the number right, and you want to make sure that you get it done in the year that it is required. So any questions about that, type it in the chat box. I will be glad to answer or address that. Let's move on. I don't see any questions at this point. So just a couple of quick examples about RMDs and how they work in a more practical sense. So we've got a 73-year-old couple, John and Jane. They need $40,000 of income from their retirement accounts to support their lifestyle. And to be clear, in this example, this would be retirement account money in addition to pensions, Social Security, or other sources of income. So we're just talking about the money they need out of their retirement accounts. Their 2020 required minimum distribution is $32,000. So in this example, their actual lifestyle need is $40,000. Their RMD is $32,000. So their income need actually addresses their RMD because it's greater than their RMD. So they can take out more if they want, but they don't need to take out any additional because they're already meeting their RMD because they're taking out more than their RMD amount. The flip side of that scenario is another couple, Tommy and Tammy. They're 72. They also need $40,000 income a year from their retirement accounts to support their lifestyle. But let's say they've accumulated a much larger retirement account. And so their 2020 RMD is $67,000. So in this example, we flipped it. So now their income need of $40,000 is lower than their RMD of $67,000. And what that means is, in addition to the $40,000 that they would normally take out to support their lifestyle, they're going to be required to take out another $27,000 to meet their RMD. And that's important because A, you don't want to run afoul of the IRS and create penalties and things like that. But it's also important to know that and be able to think and plan ahead, because that additional $27,000 could trigger additional taxes. It could trigger higher Medicare premiums, a lot of other things that come into play there. So those are just a couple of examples and things to be aware of. Went the wrong way, sorry. So planning opportunities. So given these new RMD rules, what can you do? What are your options? Well, the best thing you can do is plan ahead. Clearly, if you're going to have to start taking RMDs at 72, it's better to start planning for those well ahead of time if you can, as opposed to waiting for until your 71st or 72nd birthday. So the sooner you can start thinking about these, planning around them, looking at your options and your choices, the better. One option that is often discussed is Roth conversions. So one thing you could do is potentially take some of a retirement account today, pull some of it out, pay income taxes on those dollars, convert it to a Roth IRA, and the Roth IRA, there are no future income taxes owed on those dollars. So if you take those dollars out in the future or they pass to your heirs, there's no more income taxes owed. The thinking there is you pay taxes today at a rate that you hope will be lower than future tax rates. And we're in a historically low tax rate environment right now. But generally speaking, I'm not a huge fan of Roth conversions because it's based on a lot of assumptions. And we don't know where tax rates will be in the future. We don't know what the market's going to do, because if you take money, convert it to a Roth, pay taxes today, you have to earn money through investments and savings to get that money back to where you started before you can then continue to grow. So while Roth conversions get a lot of press and are often talked about, I haven't seen a ton of situations where they make sense, but they are an option. So something to think about. And again, to summarize, Roth conversions, the thinking is pay some taxes now in the hope that you'll pay less later. There are some potential tax planning opportunities while you're working. So let's say you're working for a company that offers a 401k. Maybe instead of saving into the 401k all pre-tax dollars, which will all be subject to these RMDs, maybe you take some of those dollars and convert to a Roth 401k. Those are becoming more and more prevalent and more common, where you can contribute to both a pre-tax 401k, which is kind of a traditional retirement savings plan, and or save to a Roth 401k. And once you, if you were to retire, you could roll the Roth 401k portion into a Roth, and there would be no future taxes owed on those dollars. And there are no RMDs, required minimum distributions, on a Roth IRA. Anything in a pre-tax or traditional 401k, you could leave in the 401k or roll it to an IRA, and they would be subject to these RMD rules we're talking about. So something to be aware of there. And then you can think about tax planning after retirement. So as I mentioned earlier, the best time to plan or think about this is sooner than later. So let's say you're retired and you're 62, your full-time income goes away. Perhaps you're in a lower income situation for the next few years. It may make sense to do some Roth conversions because you're in a lower tax bracket and you could afford to do so before required minimum distributions begin, maybe before Social Security begins. So there may be a kind of a lull in, let's say, your early to mid 60s if you're retired, and if you defer Social Security, if you are not receiving a pension and your RMDs don't begin until you reach age 72, there may be a period of time where doing some partial Roth conversions for a subsequent number of years makes sense because you're in a lower tax bracket. So that's something you might consider doing annually while you're in retirement. Over your lifetime, you might think about how to structure your RMDs relative to your charitable giving. There are some strategies and things you can utilize there, as well as generational, and that gets into beneficiary planning, which I'll touch on a little bit more here in a moment. So if anyone, again, has any questions on any of this, type it in. Happy to address that. I think everyone on the call, I recognize your name, so I think you're at least somewhat familiar with who I am and what I do, but I just wanted to highlight the fact that in addition to this webinar, you're welcome to visit my website, wealthcareforwomen.com, where I've got now over 275 articles that I've written on everything from retirement planning to estate planning, investing, widowhood, divorce, and a whole lot more. So I also have some free resources on there. And I'm also, at the end of this presentation, offering a free consultation. So if anyone's interested in that, stay tuned. So the second major provision in the Secure Act is the elimination of the stretch IRA. So what is a stretch IRA? Before January 1st of this year, if you were an IRA or retirement account owner and you passed away and you designated some or all of your IRA or retirement account to go to a non-spouse beneficiary. So let's say you left it to a sibling, to a child, to a grandchild. They could utilize what's called a stretch IRA, meaning they could take their portion of your IRA, put it into an inherited IRA in their name. They would then have to start taking their own required minimum distributions each and every year, starting immediately for the rest of their life, and that those required minimum distributions would be on the beneficiaries or the recipient's life expectancy. So for example, you pass away, you leave $100,000 of your IRA to a 25-year-old grandchild. Your grandchild could take their $100,000 of your IRA, put it into an IRA in their own name, and then they would have to start taking minimum distributions each and every year for the rest of their lives. But it's called a stretch IRA because they can literally stretch out that tax liability over what is probably 50, 60 or more years. No more. With the Secure Act, stretch IRAs are no longer available to non-spouse beneficiaries. And there are some specifics around who this applies for or to and who does not. But the bottom line is the new rules apply to designated beneficiaries. There are no changes for non-designated beneficiaries. A non-designated beneficiary, in simple terms, is a beneficiary that does not have a birthday. So for example, let's say you set up an IRA or 401k and you list your estate as the beneficiary. Your estate is a non-designated beneficiary because it does not have a birthday. It could also apply to a charity, to some trusts. So I don't think many of you are going to run afoul of that, but the bottom line is non-designated beneficiaries, the rules haven't changed. The new rules apply to designated beneficiaries. that aren't eligible to continue with the old rules. And I'll further explain that in a minute. So let's say you're a designated beneficiary, you're not a surviving spouse. You can no longer stretch the IRA assets over your lifetime. What do you do now? Well, now, as opposed to stretching them, you have to take all of the money out by the end of the 10th year after the account owner's death. So let's say Bob has a 401k. He leaves it to his nephew, Jim. Bob passes away this year. The IRA goes to Jim. Jim has to take all of the money out of the IRA he inherited from Bob by the end of the year 2030, 10 years from today. He doesn't have to take any money out in the intervening years. He can leave the money in there and take it all out in the 10th year. There's no requirement for him to take out money each and every year, but all the money has to be out by the end of the 10th year. So whereas formerly Jim could take Bob's IRA, stretch it out over his life expectancy, if he passes away and there's still assets left, he could pass it to his heirs and they could continue to stretch it out. No more. Now it all has to be distributed over 10 years or by the end of the 10th year. Let's see, I'm gonna pause here. We'll get a quick question. Bear with me here. So, so Ronnie asked about her husband who passed away. He was born in June of 1950. He passed away. She inherited his IRA, and she's asking about when she has to start taking required minimum distributions. If you're a spousal beneficiary, which in this case she would be, and you receive, you're a beneficiary and you receive your deceased spouse retirement account or IRA, you basically treat that as your own IRA. So the rules then transfer to you. So Ronnie, to answer your question, your RMDs are going to be based on your date of birth. So if you are born on July 1st of 1949 or later, you would start RMDs at 72. So hopefully that answers that question, but a good question, and thanks for asking. Any other questions or comments, type those in. So Janie asks, with all this in mind, what's the best way to handle the beneficiary of an annuity? Leave it to spouse or to the trust? So an annuity is interesting because it depends on whether or not the annuity is inside of an IRA and is considered qualified, or outside of an IRA and is considered non-qualified. If it's inside of an IRA, it's going to be basically subject to the same rules as the IRA that it is that it's housed under. If it's outside of an IRA, you're not going to be subject to RMD rules, but you still have to consider annuitization and things like that. Janie, I would say the best thing to do would probably be to discuss that with your estate planning attorney and figure out the best way to make the decision about beneficiaries in context of your overall estate plan. But generally speaking, I would probably say it's better to leave it to a spouse as opposed to a trust, because a lot of trusts that have formerly been designated as beneficiaries are no longer going to be valid, because and again, I'm not an estate planning attorney, but a lot of those trusts were basically set up as conduit or pass-through trusts, and so they basically have lost the ability to act as a vehicle to continue to stretch the IRA. So if you have a trust in place, I would go back to your attorney that helped you draft that and review that with them. So not a great answer to your question, Janie, but hopefully that helps. You said outside, so it's non-qualified. So it's not an IRA. I would probably designate your spouse as beneficiary, but would also get input from your estate planning attorney, because they're going to be more familiar with the stipulations in your trust. So these are great questions. Thank you, by the way. Keep them coming. So getting back to the stretch IRA, as I mentioned, if you receive the IRA assets as a beneficiary, you're not a spouse, you have to take them all out by the end of the 10th year. You've got some flexibility because you don't have to take the money out in the intervening years. You can take them out, you can take it all out in the first year, you can take it all out in the 10th year, you can take a little bit out each year, but you have some flexibility there. And as you'll see in a minute, that may come into play and be helpful. If you're a non-designated beneficiary, and so let's say you name your estate as the beneficiary of your will, and let's say you are 68 years old and you pass away. So if you pass away before you were required to start your own required minimum distributions, and it passes to your will, all of the IRA has to be paid out within 5 years. And that's been a rule for a while. That hasn't changed. If, let's say you're 73, same scenario, you leave your IRA to your estate, you're now beyond your required minimum distribution beginning date. If you pass away and you designate your estate as the beneficiary, your estate can now receive those funds and take out distributions for the single life expectancy of the account owner. So this is getting a little technical. I don't want to get too deep in the weeds. That might be a question for an estate planning attorney if you're getting into trust planning and things like that, but something to be aware of. Let's see. Yeah, so Ronnie asked another question about some information she's been given about having inherited her husband's IRA, and yeah, I agree, Ronnie. I would definitely reach out to those institutions and double and triple check to make sure that you're getting accurate information. If it's something you'd like to discuss further or like for me to look at, I'd be glad to. But it sounds like she might be getting some different information about when she has to start taking money out of the IRA that she inherited from her husband, her husband when he passed away. Okay, this chart. This is just a little, hopefully clear explanation of the differences between different types of beneficiaries. So over here on the left are eligible designated beneficiaries. These are beneficiaries for whom the new 10-year required payout of inherited IRA assets does not apply. So these beneficiaries can continue to utilize the stretch IRA. So minor children of the decedent up until they reach age of majority, disabled persons, chronically ill, beneficiaries that are not more than 10 years younger than the account owner, spouses, and some trusts. So everyone in this category over here on the left can continue to utilize essentially the stretch IRA, or can basically take the IRA assets, put them in their own IRA, treat them as their own, and continue to operate that way. Designated beneficiaries, so non-spouses and some trusts, these are the beneficiaries that are now going to be subject to the new 10-year payout rule. And then over here on the right, non-designated beneficiaries. Again, these are beneficiaries that don't have a birth date. So they may be charities, naming your estate as a beneficiary, some trusts. They're going to have to basically take the assets out in 5 years if the account owner passed away prior to their required minimum distributions beginning. If they survived and lived beyond the date that their required minimum distributions began, then the beneficiary would have to take out or has the option to take out IRA benefits, IRA assets based on the single life payout of the account owner. So that's a couple of more details about that. And maybe this kind of helps differentiate one beneficiary from another. So let's talk about non-spouse beneficiary example 1. So Renee is, let's say she's 57. She plans to retire in 3 years at age 60. She earns $175,000 a year, and she inherits an IRA from her mom that's worth about $490,000. This goes back to what I said a moment ago about having some flexibility about when you take the dollars out. Again, she's a non-spouse beneficiary. She has to take all the money out by the end of year 10. But rather than starting to take money out in equal installments over 10 years at $49,000 a year, she might instead wait until she retires. So if she reaches age 60 her $175,000 income goes away. She could then start taking $70,000 out per year over the next 7 years. So she's taken more money out, but her income's gone away. So she's likely going to be in a much lower tax bracket, and she'll probably get more net after-tax inherited dollars through the IRA. So this is just one simple example of how thinking about and planning with the timing of the IRA distributions for non-spousal beneficiaries might come into play. Let's look at another example. So Donnie and Marie just retired at the end of this past year. Their retirement plan is based on them spending $120,000 per year throughout their retirement. Donnie's dad is a widower. He's in poor health. Donnie is an only child and the sole beneficiary of his dad's $1.5 million IRA. So this brings into This takes into account the opportunity to maybe do some planning around the potential inherited IRA while the account owner, in this case Donnie's father, is still alive. And this gives some more opportunities for planning, but it can also make it a little bit tricky. And this can also introduce the idea of looking at Donnie's dad's tax bracket versus Donnie and Marie's and things like that. So what are some planning opportunities that we might think about here? Well, Donnie and Marie, if they just retired and they're spending $120,000 a year, they're probably going to be in a relatively high tax bracket. But their father, even though he has a large, Donnie's father has a large IRA, he may or may not be in a high tax bracket. He might not have a lot of ongoing income. So he might be in a relatively lower tax bracket compared to Donnie and Marie. So he might want to consider doing some Roth conversions while he's living, because he can convert at a lower tax bracket, take some of his IRA dollars and basically get them outside of the IRA rules, get them into a Roth IRA to eliminate future taxes. The question then comes into play is, does it make sense to for Donnie's dad to pay taxes and do that now? Is that going to be more efficient or more cost effective than passing the dollars to Donnie and Marie? This is just a hypothetical example, so I can't say, but something to think about. Also, if Donnie's dad passes away, they receive the entire IRA. They're already spending $120,000 a year. They have to take that money out over 10 years. Let's say they take it out over 10 years. So that's $150,000 a year. They're already spending $120,000 a year. Assuming majority of that $120,000 they're spending is taxable, that puts them at $270,000 of roughly taxable income. Income-based Medicare premiums go up above $174,000 in income. So it could also impact their Medicare premiums. It could also reduce or eliminate other income-based tax deductions and credits. So there's a lot of moving parts here. The bottom line is it's good to be aware of and think about these things and consider the after-tax impact on a potential inheritance. Having said all that, I believe very strongly that priority one is to plan for yourself and your lifestyle and make decisions based on what's important for you and your family and those you care about. I don't think you should let taxes and tax considerations completely drive your decisions. And I've met a lot of people that do that. And I think that's kind of backwards thinking. I think it's smart to be aware of taxes and let them inform your decisions, but I don't think you should make decisions solely based on taxes. So it's just another factor that should come into your decision making. Let's see. No questions, I'll keep going. So let's talk about strategic beneficiary planning. So let's say your father is 84. He's got a $1.8 million IRA. Your mom is still living. Rather than leaving his entire IRA to your mom at his death, let's say he's leaving half to her because of their financial situation. She doesn't need all the IRA assets. So he's leaving half to his surviving wife, surviving spouse, and he's leaving the other half to be split between you and your sibling, your brother in this example. So what this does is it effectively spreads out the tax liability. If he left it all to his wife, she could take the entire IRA, put it in her name, and then when she ultimately passed away, you and your brother would split the entire $1.8 million and have to take all those dollars out over 10 years. So you'd each have to take $900,000 out over 10 years. Instead, in this example, he's passing half of the $1.8 million, $900,000, directly to you and your brother to be split in half. So you would each get $450,000 that had to be paid out over 10 years. And then later, when your mom passes away, the other $900,000 would be passed to you to again be split in half and spread out over 10 years. So what this effectively does is, assuming that the $1.8 million IRA stays intact, this basically takes the 10-year window and spreads it to 20 years. Because if you receive assets directly from the account owner as a non-spouse beneficiary, that creates one 10-year window. And then if your mother passes away later, in this example, and you receive the remaining assets of the IRA, that creates another 10-year window. And so assuming there's no overlap, that could be a 20-year window. If there's some overlap, maybe less than that. But that's a way to spread out the tax liability. And that's a way to think a little bit more strategically about naming beneficiaries. Another way to think about it would be to not only name children, but maybe even think about adult grandchildren. You could even consider naming minors, minor children, as an IRA beneficiary. Minors can't inherit dollars, but they could take the dollars and put it into a custodial account. They would, while they're a minor, they would have to take out required minimum distributions. And then once they reach age of majority, let's say age 18, that would be when their 10-year payout window starts, or the clock starts. So in the example that your grandchild or great-grandchild is 1 year old, he receives some IRA assets. Those dollars could stay in a custodial IRA for his or her benefit until he or she reaches age 18, and they would have to take out required minimum distributions until age 18. And then once they reach age 18, that's when the 10-year clock starts and they have to pay out all of those benefits. So you could take what would otherwise be a 10-year payout window and turn that to, in this example, 27 years. So again, as I've said, you need to do what makes sense for you, your family, your situation, based on your lifestyle, what's important to you. You shouldn't let these tax considerations drive your decisions, but they should certainly inform your decisions. So that's just another way to think about how you might be a little bit more strategic in naming beneficiaries to perhaps spread out what might otherwise be just a 10-year payout on those taxes. Any questions on that? Type them in, let me know. So planning opportunities. We've already touched on these, but think about not just your own IRAs, but if you have parents living, maybe think about what they may do or may want to consider in their own planning. If ultimately they have shared with you that they want to pass retirement assets to you or to your children, maybe have a discussion with them about how they're thinking about naming their beneficiaries, how that money will now pass, how it will be taxed, and just think about ways to be a little bit more strategic there. There's a bullet here, as I've mentioned a couple times already. Prioritize your lifestyle needs over trying to reduce your tax bill. But as I've said, let tax considerations inform your decisions. I think that's important. Other ideas for either yourself or your parents as you're planning around this, or for others. Roth conversions I've talked about. I've seen situations where it makes sense, but they are, in my experience, they're the exception and not the rule. I've met other advisors and talked to others that think everyone should do Roth conversions every year up until they have to start required minimum distributions. I don't necessarily agree with that, but it is a strategy that, given your personal tax situation, might make sense. Another thing that you or other retirement account owners might consider are using QCDs. So this is yet another acronym, qualified charitable distributions. So if you're already charitably inclined, you're giving money to a church, a parish, synagogue, another organization that's important to you, but you've been just giving assets or appreciated stock, you might consider giving money directly from your IRA. Now, to be clear, you can't take money out of your IRA and then give it to the charity. You have to for it to qualify as a qualified charitable distribution, the money has to go directly from your IRA to the charity. You can do up to $100,000 a year. You don't get a charitable deduction, but instead of having to pay taxes on that required minimum distribution, that effectively becomes a non-taxable charitable gift. And so that's another way to think about that. And then, as I mentioned here, Roth conversion may make sense for you or your parents. We're about to wrap up. How did I do on time? I'm running about 41 minutes. Any questions about any of this before we start to wrap things up? Anything you want me to go back and review? Anything that I didn't touch on that you might have had a question about? Type it in and let me know. I will be happy to address that. Let's see here. So wrapping up. I've said multiple times, plan early and often. If you're going to be required to start required minimum distributions at 72, it makes a lot of sense to start planning for those at 61 as opposed to 71. It just gives you more time, potentially more choice, more flexibility, more options to think about. Plan both for yourself as well as for your extended family. So that could include parents, aunts, uncles. If you have adult children, they might need to be made aware of some of these things as well. Think about charitable strategies. So like I said with the taxes, if you shouldn't let taxes drive your decisions. If you're not already charitably inclined, I don't know that you should go out and start making qualified charitable distributions. But if you're already making charitable contributions to a qualified 501c3 charity, making them directly out of your IRA may make sense, and that's something to consider because those dollars would then no longer be subject to RMD taxes, RMDs or taxes. They would also no longer be passed on to a non-spouse beneficiary that would have to take them out over 10 years. Consider strategic beneficiaries. So instead of having everything go to your surviving spouse as primary beneficiary and maybe your children as contingent beneficiaries, maybe consider including your children or even grandchildren as partial primary beneficiaries to go ahead and have some of those dollars go direct and to pass a lower dollar amount to a non-spouse beneficiary. So maybe you can spread out the tax liability over multiple 10-year payout windows. Roth conversions, I've touched on multiple times. And I will say, this is the latest retirement legislation. At the end of 2018, there was the TCJA Act, and we've seen more legislation like this in the past. We will inevitably see more. So these are the rules that we're playing by now, and I hope I've helped familiarize you with some of the ins and outs and considerations that revolve around this, but I would tell you to expect more change in the future. And that's another reason why I'm a little wary about making any big sweeping financial decisions like a Roth conversion, because who knows what the government's going to do with the treatment of Roth IRAs or tax rates or things like that in the future. They could turn out to be a great decision for everyone that does them, but we don't know. And so there's a lot of unknowns there and something to be aware of. And one last time, I touch on, don't let taxes drive your decisions. Focus on your life and your lifestyle first, but certainly take them into account. Everyone on this call, I think, is pretty familiar with me and who I am and what I do. But as a reminder, I invite you to visit my website. If you'd like to schedule a consultation, you can go here to wealthcareforwomen.com/call. I work with clients in and around Atlanta as well as remotely, scattered all over the country, and would be happy to talk to you about your retirement planning, your financial planning, your beneficiaries, any of the things we've talked about here today. So as we're wrapping up, if anyone has any final questions or comments, this is all of the content that I had planned to cover with you today, but I'm happy to address anything that might be on any of your minds. As a financial advisor, I operate in a highly regulated industry, and so my compliance attorneys made me promise to share this last slide. If you If you're having trouble sleeping at night, if you suffer from insomnia, go to wealthcareforwomen.com/disclosures. There's plenty of stuff there that will knock you out and make you sleep like a baby. Having said all that, any questions, any comments, anything else that I can address or revisit about the Secure Act with regard to required minimum distributions, stretch IRAs, or anything, anything in either of those areas? All right, so I don't see any other questions coming in. So we'll wrap it up. Thank you so much for joining us. I am happy that you elected to spend a little time with us this afternoon. I hope this was helpful. And if you need anything in the future, feel welcome to reach out and let me know. For now, have a great evening, and thanks again.